And present for the board, we have Mr. Ron Kreitz, Mr. Ed Grafton, Jennifer Greenleaf's our counsel. We've got John Hunter, Dr. Henry Roush, who was here in the previous hearings, is not here today. We may try to get the information to him so he can review it, but he's not here. I'm the chairman, Jim Smith, and I think we're ready to proceed. If first, maybe we could get counsel to introduce themselves for the record so that she'll have that, please.
Yeah. William DiPaolo, counsel for the Cordell appellants.
Tom Rose, counsel for the Boulas appellants.
Jason Wandling for the DEP.
Ralph Hoyer, Christopher Smith, and Nikki Smith of Hoyer and Smith for the permittee.
Boris Jones, Jones and Associate for Revelation Energy.
Thank you. Before we start, do we have a procedural issue that
Yes,
we need to
and
talk
this
about?
is strictly a courtesy request. I've got a witness, Paul Corbett Brown, who's the president and chairman of Keepers of the Mountains Foundation. I'm going to claim him as a witness for the sole purpose of authenticating a document. And I'd like to take him out of sequence if I could, just so and that doesn't resolve that, admissibility. Obviously, there's a relevance issue, and I understand the other side probably will argue strenuously that it's not admissible, which is fine. But all I want to do is establish the authenticity of the document. I think Mr. Hoyer is comfortable with it. I think counsel for the DEP would like to ask a few questions, but it would take just a few minutes, and if we could get that out of the way, it would permit us to, would permit him to go to an appointment on the other side of town if he wanted.
Mr. Wandling, you have any comment on that?
No, I mean, it's fine taking him out of turn, that's fine with me.
The only question that I have, Mr. Chairman, it was my understanding that Mr. DiPaolo rested his case. So I don't have any problem with what he's asking to be done, but I don't know how he's going to introduce it.
Wait, do we, Mr. Jones, do you have anything?
I would join in Mr. Hoyer's objection.
Short
As
answer
I
is
recall, you did rest your case.
That's absolutely correct, and I'm going to call this gentleman as a rebuttal witness.
Yeah.
Are we okay?
To what?
Well, I anticipate that the other side, you can always reject it on relevance later, which, if they just rested and did nothing, I agree, it would not be admissible. I expect them to defend their position that they could go forward without SHPO approval. And this is, in support of my position that they needed SHPO approval.
Right.
And all we're doing here is on authenticity.
Okay.
We can argue about every other issue later.
Right.
But
He's
if
just
they
going
don't
to
wanna do it,
testify.
that's fine.
No, he's going to testify as to authenticity of a document that you.
Correct,
And
that's
you
right.
think may be, and he has another appointment now that he has to
Correct,
go.
that's it.
Let's let him go ahead and do that
Okay.
then.
And for the benefit of the board, I've got volume 2 of my effort to deforest America in front of you there. And the document that he's going to be referring to is exhibit number 009, which begins on page 98.
And if I could clarify something too, just procedurally to make sure so our records later on is clear, is if there was some sort of objection or something brought up in a later appeal about him being called and somehow being out of turn, I would state for the record that I would have called Mr. Brown as a witness since I've not rested my case and we're the appellants, and this would have, I believe, come in that way anyway.
Okay,
Thank you.
Tell us your name, please.
My name is Paul Corbett Brown.
What's your position with Keeper of the Mountains Foundation?
I'm the president and chair.
Okay, I'd ask you to direct your attention to the document beginning at page 98 of the materials in your hand, which,
Excuse me if we could. I didn't get your name. I'm sorry.
Paul Corbett Brown.
Okay, thank you. I'm sorry.
beginning with, has the phrase Exhibit 9 in the top right, and it appears to be a letter dated August 18th, 2014, and it appears to be from the West Virginia Department of Division of Culture and History. Can you tell me what this is?
Yes, this is a response to a Freedom of Information request.
Okay, and if you would, turn your attention to the page immediately opposite that, beginning with page 99 and continuing for the next two pages, two hard copy pages. 99, 100, 101, and 102. Could you tell us what that is?
This is a SHPO response to an application for a mining.
And was it attached to, or was it produced in response to the FOIA request?
It was, in fact.
Were other documents produced?
Yes, it were.
Approximately how many?
It was a stack about an inch thick.
Okay. No further questions, but I'll, submit the authenticity is established.
Hi, Mr. Brown. We've met before. Jason Wandlin for the DEP. Are you? Do you work for the DEP?
No, sir, I do not.
Do you work for the West Virginia Division of Culture and History?
No, sir, I do not.
Do you work for CCI Cyrus River Terminal LLC and Consultants?
No, sir, I do not.
Do you have any involvement with mining activities at the Roswell Cyrus Farm?
No, sir, I do not.
Were you a party to this alleged memorandum of agreement?
No, sir.
Were you present at its creation?
No, sir.
Were you there when Mr. Halstead or Ms. Pierce allegedly signed it, as sort of shown here on page 102?
No.
And do you know why Leanne M. Plagens, Plagens, did not sign or date the agreement?
I do not.
No further questions.
No questions, Mr. Chairman.
Mr. Jones?
I just have one question for clarification. I notice on page 98, which is the cover letter dated August 18, is addressed to William V. DiPaolo, counsel in this case. It is the attachment that has been referred to, that's 99, 100, 101, and 102 pages. Was that part of the response to the August 18 letter?
I'm sorry, I don't
Was
understand your
that
question.
part of the response, or the documents included with the August 18 letter?
I'm
That's been
really,
asked and answered. I asked him that question.
Well, I would ask if you'd clarify what he
He's
answered,
asking for a
please.
clarification, right?
I guess my question, let me rephrase the question. Did you receive this memorandum of agreement as part of the documents furnished with the August 18 letter that's shown on page 98?
yes, we did.
Well, did you receive this, or did Mr. DiPaolo receive this?
I'm not sure. I mean, we received this. Keeper of the Mountains received this. Keeper of the Mountains requested this.
Well, this letter isn't addressed to Keeper of the Mountains. It's addressed to Mr. DiPaolo, counsel in the case. And I guess my question is, how can you verify something is complete that was not addressed to you?
Keeper of the Mountains requested this through Mr. DiPaolo. Mr. DiPaolo picked up the documents, and I was there. I came to his office to see the documents myself.
So you didn't originally receive the documents. Mr. DiPaolo did, correct?
That's correct.
I have no further questions.
Are we done?
We're done. We're more than done.
I do have one question, actually.
Yes, sir.
What other documents were received?
Again, asked and answered.
Well, I think, are you saying that your understanding is that the documents that came from in the FOIA included this letter on August 18th and this memorandum of agreement?
That is correct. There was a stack of about an inch thick of documents that came with this letter. Not complete.
Go ahead.
Yeah, well, what my question is, what other, how is this one document removed from the stack of however many other documents were received?
Objection to relevance. I mean, it has nothing to do with establishing the authenticity of the document. It's a legal issue he can raise later.
Yeah, we'll consider, let us consider that and give the board give weight to this as we go. Mr. Didn't mean to skip you. Did you have any issue here?
If I'm quiet, it's because I'm not paying attention.
Okay.
No, I'm kidding, I don't have any
Is
questions.
the witness excused?
Does the board have any questions for the witness? Then you're excused. Thank you.
Thank you.
Thank you. And just for the record, if counsel for the DEP wants to put me on the witness to establish a chain of custody from my hand to Mr. Brown's hand, I'll be happy to do that at any point he wants it.
Okay. Okay. Are you ready, Mr. Rist?
I am.
Go forward.
Yeah, I would call Frank Jezero.
As we do this, did you have, my understanding, if my memory is correct, you had one witness to call? Did you?
That's correct.
Okay.
Yes, sir.
And this is he.
This is
Mr.
him.
Chairman,
Yeah.
can I have something?
Sure.
I have misplaced my hearing aids, so if people could, speak up, it would help me.
Sure.
And if you see me going like this, that means speak up a little louder, please.
Doesn't mean we're doing a good job. It's not the.
No, doesn't-
Yeah, and that's fine, as
You'll
long
have
as
to
no one on
determine
YouTube
that.
thinks we're screaming at them.
Like the board's giving me the thumbs up. This is good.
Mr. Chairman, I need you to raise your right hand. Swear you and your solemnly swear affirmative testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Good morning, Mr. Jezero. How are you today?
Fine, thank you. You?
First, I'm good, thanks. Let me make sure I am pronouncing your name right. Jezero.
Correct.
I've had to actually work on that because I want to call it Jezerio phonetically. It's Jezero.
Correct.
What is your job position, sir?
Director of the West Virginia Division of Natural Resources.
What do you do overall in that position as the director of the DNR?
Overall, the DNR, I'm over basically what we consider 5 sections. Law enforcement, wildlife, state parks, administration, and land and streams. So I have 800 employees and 5 section heads who head up those various sections.
I'll cut straight to the chase and ask you, what does the DNR, what is their involvement with Kanawha State Forest?
We own Kanawha State Forest, so to speak. Let me back up. The people of West Virginia own it, and the DNR manages or looks out for their interest in the state forest.
And that, you got to something I was gonna ask you, anyway, so the Kanawha State Forest would be considered something owned by the people, the taxpayers of the state of West Virginia?
Correct.
And is the West Virginia DNR, are you guys a state agency funded by the taxpayers of West Virginia as well?
We receive some tax dollars, yes.
Okay, all right. I want to discuss the mining permit that's at issue in this case, obviously. And I'll get to some of the exhibits here in a
Sure.
minute, but I just wanted to ask you generally, before we look at something, do you recall working in some manner on this mine permit?
Yeah, going back to when this began, and I think this may have been somewhere around 2010 or 11 or something, it was brought to our attention that there was a company wanting to mine land, private land, near the Kanawha State Forest. So at that time, our chief of parks and our district administrators started contact with DEP and with the people who owned the minerals and owned the land near the state forest.
Do you have any idea who it was that first contacted you, the DNR, from the DEP?
As I recall, it could have been Mr. Clark. I think that seems to me to be the first name that I recall.
Is that Tom Clark?
Yes.
Do you recall what it is he asked of the DNR at that time?
At that time, as I recall, he was raising the issue that the DNR would have to participate in the issuing of a permit to mine this land adjacent to the forest, because they were considering the state forest to be what you would consider a state park. We disagreed. We felt that this was a state forest and not a state park. But as time went on, DEP produced some information that said they had used this same definition in the past, I believe, and they considered this to be under what they would call a state park for mining purposes.
All right. Let me, if I can approach the witness without falling over.
Do you want us to stand or document?
No, you're good. There's one for each. Me going that way. can tell my secretary's back at work since I've got everything right today.
I'd like to have this marked as Exhibit 5.
It's
4? Exhibit 5? Okay, I'd like to have this marked as Exhibit 5, please.
And there's copies for each board member. Pass that down. Thank you. And for the record, this is out of the certified record. In the certified record, it's page 212, 213, and 214. And the first question I would have, Mr. Jezero, is, do you recognize this document?
Yes,
Okay. And it's a 3-page document with your signature at the end, is that correct?
correct.
All right. And it appears that it was written or sent to Tom Clark. Is that correct?
Yes,
At the DEP? Contacted state. .213 in the certified record. That paragraph says, "It is the opinion of Parks that development of the mine as described in the materials and mapping which were provided will indeed impact the forest and the experience of many of its visitors." Did I read that correctly?
yes,
And at this time, in June 23rd, 2010, the opinion of the West Virginia DNR was that this development was going to impact the forest. Is that correct?
correct.
And then you listed here in the rest of the letter some issues that were brought up, including the views and vistas and sound from mining operations. Is that right?
Correct.
Three for that way. If I can approach the witness again, I'd like to have this marked as exhibit number 6. This is for you guys as well, thank you. I've got this. In the certified record, Exhibit 6 is page 215 and 216. And Mr. Jezero, I'll direct you on this document to look at the second page. It appears that you were CC'd on this at some point.
Yes,
Do you recall when it is that you received this?
no, I don't.
And this appears date-wise to follow exhibit number 5 by roughly a month. Is that right?
According to the date, yes.
Okay. And do you recall reading this letter when it came in?
No, I don't.
Is there any reason to believe that you would not have received this letter, though, since you were CC'd on it?
Oh, no, no,
Okay.
it's just a matter that I don't recall
Okay.
reading.
You probably get hundreds of letters a day, don't you?
Yes.
All right. In this letter, the first paragraph
notes that the West Virginia Code Section 22-3-22D2 prohibits surface mining operations which will adversely affect any publicly owned park unless the operations are jointly approved by the DEP and the agency with jurisdiction over the park. And then one sentence after that says the terms, in quotation marks, publicly owned park and public park, both in quotation marks, are not defined in the West Virginia surface mining statutes or regulations. In cases where there are gaps like this in state law, decisions of the West Virginia Supreme Court of Appeals require the DEP to look to federal surface mining law for guidance. And then it notes that previously the DEP has determined that Kanawha State Forest falls within the definitions of these terms in federal law, and it cites 30 CFR section 761.5. First of all, did I read that correctly?
Yes.
All right. Sir, are you familiar with 30 CFR section 761.5?
Roughly, yes.
And I'm going to approach and hand you a copy of that code section. I'm going to mark this as Exhibit 7. And what I've handed you is 30 CFR 761.5. And we've blown up to the right there the definition of what a public park is in the federal surface mine regs. And that states public park means an area or portion of an area dedicated or designated by any federal, state, or local agency primarily for public recreational use, whether or not such use is limited to certain times or days, including any land leased, reserved, or held open to the public because of that use. And again, did I read that correctly?
Yes.
Is Kanawha State Forest a publicly owned land where recreational use occurs?
Objection requires a legal conclusion from the witness.
Join the objection.
That's a factual question to the head of the West Virginia DNR as to whether Kanawha State Forest is a recreational area. He testified previously that the DNR is indeed the owner and manages that land. I think it's a factual basis he could answer.
The definition of whether it's a park or something is a legal issue. Even he has a disagreement with the DEP about it. I don't see what value. This is cited in their brief, and we argued it. And it doesn't matter whether it's a park anyway, because he approved it. So I don't know where we're going.
Well, let's say this, that there are a lot of different opinions here today about these terms. Let's see what his opinion is, and the board will give it justifiable. We have all input.
You want to repeat the question?
My question, sir, is does the DNR consider Kanawha State Forest a public recreational area?
Yes.
If you could go back to the July 15th letter that I handed you that was addressed to Linda Torre, I think that's Exhibit 6.
Yes.
The second paragraph notes that because of the proximity of the above referenced SMA to Kanawha State Forest, the DEP has determined that it presents the potential to adversely affect Kanawha State Forest. And then they reference your June 23rd letter where you identified some of the concerns with the forest. Is that correct?
Yes.
And then the last paragraph on the second page, if you'll go to that. This paragraph notes that although any steps Keystone takes to mitigate or minimize the adverse effects of this proposed operation on Kanawha State Forest must be reflected in Keystone's permit application with the DEP, any discussions of measures Keystone is willing to take to mitigate or minimize the effects of this operation should also include the DNR.
Correct.
Is that what happened in this case? Did Keystone contact the DNR?
Either Keystone contacted us directly or through DEP, because there were subsequent meetings that I did not attend. Chief of Parks and the district administrator attended those meetings. But yeah, there were subsequent meetings and contacts.
And that's with the Keystone representatives, correct?
As far as I know, yes.
Now, if you would look at what was previously marked as Exhibit 1, I think is sitting to your right. And it's a December 24th, 2013 letter. This is certified record pages 217, 218, and 219. Do you recognize this letter, sir?
Yes,
And this is a letter that was signed by you, is that correct?
correct.
And this was addressed to Harold Ward at the DEP, is that right?
Yes.
And in this letter, they note that the West Virginia, or you note that the West Virginia DEP has requested the DNR give joint approval for the above referenced surface mining application, is that right?
Yes.
And that's what happened in this case, right?
Yes.
And then on down in the second paragraph, you note that the West Virginia DEP has determined that Canal State Forest is a publicly owned park, as that term is defined in 30 CFR 761.5. And the permit application therefore requires joint approval. Is that right?
Yes.
And that's what happened in this case, correct?
Yes, DEP determined that this was a park.
Let's look at some of the things that were discussed here. The next paragraph notes that the DNR had reviewed information concerning the pending application and understands Keystone has redesigned the operation with its efforts to address the DNR's concerns and to minimize impacts of Canal State Forest. And is that what eventually happened through your dealings with Keystone and the DEP?
Yes.
All right. And the list here says that they reduced the overall permit acreage. Is that right?
According to this, yes.
And the elimination of proposed valley fills. Is that something that Keystone agreed to do?
I'm assuming they did because, like I say, this information was presented to me through people who attended those meetings with Keystone and DEP, so I'm assuming that was agreed upon.
Okay. And was that what the DNR was told then, was that Keystone had agreed to eliminate valley fills?
Yes, as I recall, based on what was given to me, or we wouldn't have stated it in we're just trying to reaffirm what we understood the permit to say.
Okay. At the time that this letter was written in December of 2013, did you know as the head of the DNR that permits that had valley fills in it were not being issued anyway?
I remember reading, like everybody, that there was some question on valley fills, that they had either been curtailed or under special circumstances, but I really didn't look into it to make sure that they already had been curtailed.
And then I'm going to, on the second page, I'm going to drop down a couple of bullet points there to the seventh one. It starts out sequencing. Do you see that?
Yeah.
Okay. This says that sequencing mining so that the side of the ridge facing away from the park is mined first and the area facing the park is mined last, thereby limiting the time the area closest to the park is visibly exposed to park users. Is that one of the agreements that was brought to your attention that Keystone had made with the DNR?
Yes.
All right. Did the DNR, to your knowledge, ever request Keystone just not mine the area that faces the park?
Now, I personally didn't. I don't know if there was any discussion that I did not attend to that, but I don't remember anybody ever coming and saying, we don't want you to mine there. I don't recall that.
And then the last bullet point says limitation of blasting during times of heavier usage by the public and on weekends. To your knowledge, has that been done?
Has what been done?
This limitation of blasting during heavier times. One of the agreements was that Keystone would limit blasting during times of heavier usage by the public and on weekends.
On this particular,
Yes, sir.
I don't think as far as I know, they're not mining there or blasting as far as I'm.
Well, I
Are
think
you
that-
saying, are they doing it now?
Right. Now, let me break that into two questions because
Yeah.
I think I wasn't totally that wasn't the best question. First, the agreement with Keystone was they would limit blasting during times of heavier usage by the public and on weekends, correct?
Yes.
All right. And then the second part of that question is, has that been done? Do you have any idea?
No, I don't.
And you're saying no, you don't have any idea?
No, I don't have any idea if there's, are you talking about on that particular mining site?
Yes, sir. Right now, as we sit here today, do you have any idea if they've limited blasting in any way?
I personally don't know.
The last paragraph on the second page, the West Virginia DNR understands the permit applicant is willing to accept permit conditions that require it to mitigate for unavoidable impacts to the recreational resources of Kanawha State Forest. And I'm going to stop for a second there on that term, the unavoidable impacts to the recreational resources of Kanawha State Forest. Is that, first of all, this is a term that you're using in sending a letter to the DEP, right?
Yes.
And is that something that the DNR had determined, was that there was unavoidable impacts to the recreational resources of Kanawha State Forest?
What we had determined after I looked at this, if you can call it an impact, it would be what we would consider to be a break or an inconvenience to the people who used the forest. They would be times when there would be noise, and this would be an impact. There was no impact to the forest itself, to the land, to the trees. This was, due to the off-site activity, that there would be what people would consider an impact due to the noise or maybe the disruption of a hiking trail while there was blasting going on. So those were the impacts that we saw.
Okay. And so that's, would you agree that's what you would say from the DNR is a limited impact?
Yeah, I considered a limited impact or a temporary inconvenience. This wasn't permanent, to my understanding. This was something that was going to take place, eventually end, and it would be gone.
Okay. And then the next part of this says and I'm sorry I stopped mid-sentence there, but after the unavoidable impacts to the recreational resources, it continues and says, of Kanawha State Forest by dredging the fish pond there and paying compensatory mitigation to the West Virginia DNR in the amount of 10 cents per ton for coal mined from the permit. Did I read that right?
Yes.
Is it your understanding that that's over $700,000 total, based on what the estimates are?
Yeah, that's what's been presented to us.
And they're also dredging the fish pond, and I think I saw somewhere at a cost of about $200,000.
That's probably correct.
Why is that being done?
You'll have to ask, well, a couple of things. The dredging of the pond, I imagine, they may have asked the superintendent of the park or the park's chief, which often happens when companies that have large equipment are in on somebody's land. They often ask, is there something we might do with this equipment that would help you? And if that took place, then probably somebody said, well, it'd be nice if we could get this pond dredged.
How about this payment of almost $750,000? Why is that being done?
That's a good question. You'll have to ask the people who negotiated that, I guess. DNR had no involvement in that. It was presented to us along with the permit from DEP that there had been an agreement that the coal company was going to voluntarily pay this 10 cents per ton. Now, I heard, would be hearsay, I guess, but I heard somebody from the coal company in an interview with Chris Lawrence or and I think they said it was simply a gesture of good faith to help the community, help the park, something they brought through voluntarily. There was never any discussion or negotiation with the DNR where anybody said, we want money or we want 20 cents, and that never happened.
Did you hear that interview after the hearing last week?
No, I think I heard that a couple of weeks ago.
Do you have any idea whether anybody, whether this coal company is paying any money to the adjoining landowners that are on the appeal?
I have no idea.
They're just giving money to Kanawha State Forest?
my understanding is just what you said, that there was an agreement with the coal company that they would pay 10 cents per ton to the DNR to be used on Kanawha State Forest for whatever reasons.
Okay, so I'm crystal clear, this wasn't negotiated by the DNR then?
No.
This was just brought to you and said, here you go, we're gonna give you this money.
Along with these changes or these considerations that they made in the permit, these points that you just went over, it was told to us that along with these concessions or changes in the permit, they are willing to go ahead and pay the DNR 10 cents per ton.
The next paragraph there on page 3 says, the last sentence says, contingent upon all of the mitigation measures set forth herein being mandatory for both permit issuance and the continuance of mining operations and other permitted activities thereafter, the requested approval of the West Virginia DNR is hereby granted.
Correct.
And so what you're saying is that as long as those mitigation measures are being done, permission is being granted.
As long as all of those conditions that were set out in these bullet points, and, you know, we assumed that DEP was going to enforce those. As long as that was done, then we were willing to grant or give our permission.
If some of these terms are not being followed as this permit progresses, is the DNR, do they intend to withdraw their permission for this permit?
I'm not sure what the legal ramifications would be. I'm not sure we have the ability to withdraw. I would think that if they weren't being met, that DEP would have the regulatory authority. Since we have no enforcement on mining rules, I would assume that they would do whatever's necessary.
Let me hand you what I'm gonna mark as exhibit number 8. For the record, this is certified record pages 285 and 286. Do you recall this letter, Mr. Cesaro?
I remember reading over this because I remember looking at the section that said something about seismograph. But again, this was probably handled direct by our chief of parks who was working with these people. But I remember seeing it.
And this came from Harold Ward at the DEP, is that right?
Yes.
All right, and Mr. Ward advised you there in the first paragraph that in addition to the conditions your agency has requested for inclusion in the above referenced permit, the Division of Mining and Reclamation is applying the following conditions to the permit. And this first bullet point says, prior to any mineral removal activity, the permittee shall establish a written agreement with the West Virginia DNR. And the rest of that paragraph follows what was in the other letter about the 10 cents a ton and dredging of the fish pond. Is that right?
Yes.
Has that written agreement been done?
I can't recall if we already have that in our hands or not, to tell you the truth, because again, a lot of this was being handled by our chief of parks. I vaguely remember seeing an agreement, but I don't know if that was it or not.
Right. Well, that agreement's not a part of the public record in this case on the permit. It just references the agreement, but you think that it's been done?
I'm just not sure.
Okay.
I've received so many things on this, I can't really remember.
This also notes that within 1 year, this is the second bullet point on page 1, that within 1 year of the permit issuance, at a time agreed with by the West Virginia DNR, the permittee will clean the fish pond located at Kanawha State Forest. Is that right?
Yes.
Was this something that was negotiated again outside of the DNR?
It could have been with the DNR, like I say, it could have been with the park superintendent, the fellow who was on site, or it could have been with the chief of parks who was working with these people, and Again, if they said there's anything we can do, he may have said it would be good to dredge that pond if you can.
Okay.
So I don't know. I had no specific involvement in that.
I'm going to approach the witness again. So I guess the clerk can have this marked as exhibit number 9. Give me our stickers. And for the record, this is certified record, page numbers 2 and 3. It's the permit face. Have you ever seen this before?
Not that I recall.
If you go to page 2. And if you'll look, numbers 5 and 6 on the permit face appear to include that 10 cents per ton for coal mine from the permit and the dredging of the fish pond. Is that right?
Yes.
And number 6 says within 1 year, the DNR will agree to a time to have the fish pond cleaned. Is that correct?
Yes.
Okay. All right, one last thing. If I can approach again and have this marked. Is exhibit number 10. And for the record, this is certified record page 325. Now, as we've gone through in this, with your testimony today, your understanding was that the DEP had labeled Canal State Forest as a park, is that right?
Correct.
A publicly owned park.
Correct.
And that's why they were seeking your approval, is that right?
Correct.
Did you have any idea that the coal company, in their permit to the DEP, had stated that no publicly owned park was going to be affected by this operation?
No.
Is this the first time you've ever been told that?
First time I can recall hearing it, yes.
I moved to have admitted the exhibits that I marked. They're part of the certified record, but I think it makes it easier that I pulled them out separate. And with that, I'd have no further questions.
No objections?
The objections to the
No objection.
commission. All right, that would be exhibits 5, 6, 7, 8, 9, and 10. Mr. Lionel? Well, yes, Mr. DiPaolo, do you have?
Yes, I have a few questions.
Sure.
Mr. Guzera, I want to let you know, it's not totally clear to me what your testimony was regarding the broad question of whether or not the payment of this 10 cents a ton was part of the quid pro quo between DNR.
Objection.
I'm laying a predicate question. Do you have an objection to me just stating that something's unclear?
It's argumentative to use the.
It's not
phrase quid
argumentative.
pro quo.
I'm laying it out.
May
I mean, he can disagree with it, okay.
Go ahead.
I mean, really.
Very much, really. I think we're supposed to
Yeah.
direct responses to the.
Right, to the
chairman.
board, please. Go ahead and ask the question.
Okay. It's not clear to me from your testimony whether the 10 cents per ton was part of the negotiation between DNR and the permittee, or if it was a gratuitous event.
Let me be extremely clear, and I apologize if I wasn't clear that you didn't understand it. DNR had no involvement in securing 10 cents per ton. There was no negotiations with DNR over money. There was no exchange of questions, or it was brought to us through the agreement that the coal company and DEP apparently reached, that they were going to voluntarily give us this 10 cents per ton of coal. Is that,
Well, that helps, but
Yeah.
let me tell you where my confusion
Sure.
comes from, and maybe you can clarify it. As I understood your narrative, at some point, you got information from the applicant regarding what they contemplated doing, and there was an exchange of information or views back and forth between your agency and the permittee regarding matters that you all would prefer to be a slightly different way or significantly different way. And I do understand your testimony to be that DNR never initiated any discussion of money, as, you know, is that correct?
yes,
Okay. But I also thought I heard in your direct testimony that after having had an exchange on a variety of issues, that when the response from the permittee came back, it included, as part of all the changes they were willing to make, it included with those the line item including 10 cents per ton.
Yes.
Is that correct? And I guess the additional term of cleaning a pond. Is that
yes,
correct? So although the DNR did not initiate it, it was, to put it in the parlance of negotiations, it was part of their counteroffer that came back to you. Is that correct?
it was brought back to us voluntarily as brought out in those points. Let me, I think I know where you're trying to go, but let me maybe make it clear. DNR never said we'll give you a permit if you give us 10 cents a ton.
I understand that
Yeah.
totally.
Yeah.
That
We
part
were
is
never,
clear.
we were never involved in any discussion about the money until it was brought to us and said, in addition to meeting those, changes that you have concerns with about the noise and the blasting and all of this, in addition to that, the coal company is willing to go ahead and pay this 10 cents per ton.
I understand that.
Yeah.
But the sequence of events was such that after having expressed your reservations on what I call the non-financial
Sure.
issues, in response to that, they had a series of responses dealing with the substance, and they included in that communication the terms relating to the 10 cents per ton and the cleaning of the body of water.
I'm not sure if that came back with those bullet points that we discussed earlier, or if that was later on. It may have been when they told us about the changes they were willing to make. I don't recall. It may have been after this December 24th letter, and I'm not real sure. But anyway, that's when they made the concessions or when they made the changes that we were concerned with. Sometime then or after, we were told that they were voluntarily going to pay this 10 cents per ton.
Well, the December 24th document was a communication from you to Harold Ward,
Yes,
correct?
yes.
And I understand that it's your testimony that DNR never initiated. Well, if you drop to the last paragraph.
Yes.
On the second page of the letter.
Right.
uh,
We're reaffirming what we've been told were the conditions that the coal company was willing to do. And after listing the conditions, the changes, we said, as that paragraph says, we understand that they're also willing to pay this 10 cents a ton and clean the fish pond.
All right, and just to get the language clear, that paragraph states, correct me if I'm wrong, in addition to the above changes that reduce the impacts on Canal State Forest, WVDNR understands that the permit applicant is willing to accept permit conditions that require it to mitigate for unavoidable impacts to the recreational resources of Canal State Forest by dredging the fish pond there and paying compensatory mitigation to WVDNR in the amount of 10 cents per ton for the coal mined from this permit, which is estimated to include 7 million tons of coal.
Yes.
And then the last sentence on the next page is contingent upon all of the mitigation measures set forth herein being mandatory for both permit issuance and the continuance of mining operations and other permitted activities thereafter. The requested approval of WVDNR is hereby granted.
Yes, yes.
Okay. Now, I'd like you, if you would, go to the bottom of the second page again, the paragraph that I read in full. The phrase where it says WVDNR understands that the permit applicant is willing to accept permit conditions that require it to mitigate for unavoidable impacts to the recreation resources of Canal State Forest by dredging the fish pond and paying compensatory mitigation. The phrase
Correct.
mitigate for unavoidable impacts to the recreation resources. Did anybody inside the DNR attempt to quantify what those impacts were?
Well, I think they were the same impacts we brought out in the beginning, that there would be disruption of the hiking trails possibly, or noise, vista views. To what degree, no one knew, but it would be, we all agreed or knew that there would be some disruption, and that's what we're talking about.
I understand. I may have chosen an improper term. I said quantify. I should have said monetize. Did anybody put a dollar value
No,
on that
no,
inside DNR?
no.
Are you aware of any authority as director which would allow you to accept a monetary consideration as part of mitigation for impacts on recreational resources?
There have been, I'm thinking back to, I'm trying to think if there were times when something was destroyed and land was taken or used up, and then they were given money to buy additional land to replace it, something like that. But I don't know if I'm understanding you, where the authority comes from. I'm not sure.
Okay, well, let me follow up to that
Sure.
question. In the circumstances where land was given back to you, in an instance where land might be taken, it would be relatively straightforward to appraise the land that's being given,
Yes,
correct?
yes, yes.
But you're not aware of any similar mechanism inside that DNR has available to it to assess the financial value
No,
of unavoidable impacts to recreation
no,
resources?
no, I mean, like, in other words, what's the monetary value of looking at a vista that had trees and now it doesn't?
I understand the problem. I
Yeah.
understand. 10 cents per ton times 7 million tons. I mean, I'm not real good at math, but I think that's about $700,000.
Sounds like it.
How important is $700,000 to the DNR budget?
The West Virginia State Parks, State Forest struggle continuously with the budget to make the improvements that the public wants and deserve. So yes, any money like that could be used to improve that forest for future generations would be very important.
How long have you been at DNR?
Going on 10 years.
10 years. In the time you've been there, has DNR ever denied or withheld its approval of a surface mining operation permit?
I don't ever remember being involved in one. May have been, but I don't remember.
Nothing further. Thank you.
Mr. Wanley.
Good morning, Dr. Jezreel. My name's Jason Wandling. I'm a lawyer for the DEP. I think we met briefly during the introductions. I only have a couple follow-up questions
Sure.
for you. Thank you for your testimony. Now, we were talking about on for everyone here's reference, page 218 of the certified record, that's the December 24th, 2013 letter. That's Christmas Eve. Sure, you had better things to do than writing the DEP. But I do want to point that one of the conditions for your approval of the permitted issue was that historic structures be preserved. Is that an accurate description of what the letter says? And I can point you towards the bottom. It's the second from the bottom bullet point. It says the applicant has addressed those portions of the KSF facilities which have been considered historically significant.
Yes.
And is it your understanding that one of the ways that have been developed to protect those structures is the seismographic readings, correct?
Yes.
Well, Director, I appreciate your time. I have no further questions for you.
Thank you. Dr. Dresero, I have several questions relating to your testimony. You testified you have been director for some 10 years, is that correct?
Going on 10 years, correct.
And during the period of 2009, 2010, when these letters were transmitted between you and DEP and Mr. Clark, were you aware that mining was currently being conducted adjacent to Kanawha State Forest on the 6,000 acres under a permit known as KD No?
Well, I remember discussions that there's something to the effect that there is already mining taking place adjacent to, but not as close to the forest or something like that.
All right.
Yes.
And this, I refer to a KD No permit. Are you familiar with that it was issued in 2006?
No, I don't know what the number of the permit. I remember someone saying, or during our discussions, that there is already mining taking place somewhere in that area.
Were you aware that mining had been conducted on that adjacent property for some 48 years?
That's part of the discussion that I heard, was that they've already been mining there.
Okay. Do you know of any adverse impact to Kanawha State Forest resulting from the surface mining that was conducted adjacent to Kanawha State Forest over that 48-year period?
Objection, no foundation. It's only there 10 years, has no basis for any opinion any time prior to that. And has expressed no knowledge of the actual mining activity that occurred in the 10 years he was.
Well, it would be interesting to know if anything's occurred in the 10 years. If he has any knowledge, he can state that directly, whether he
Nothing has ever been brought to my attention by the parks people or the superintendent that says, you know, we've got damage here and we think it was caused by mining. No, in the 10 years I've been here, I don't remember anything coming like that.
It is a fact that DNR did, through you, give its consent for the issuance of this permit. Is that correct?
Yes.
And this is a surface mine permit?
Yes.
It is not a mountaintop removal permit?
Objection. That calls for opinion that can't be provided by Mr. Jezero as a DNR employee.
Right, he can't offer it as an expert opinion. He can state what his impression is, I guess, if you like.
Certainly. He responded to all this correspondence reflecting the substance of that correspondence as a surface mine permit.
My understanding is that it was a surface mining permit.
When the payment of $700,000 was negotiated between what you think to be the permittee and DEP, is that correct? That's how you thought it would happen?
It wasn't with DNR, so it had to be somebody whoever else was involved in the discussions.
Okay. Is it your understanding that that $700,000 will be used solely for the benefit of Kanawha State Forest?
Yeah, my understanding is that it would be used on that forest to make improvements or whatever we could do on that forest, again, for generations to come. No one ever, there was never any discussion, well, we can take some of that money and we'll use it over Tiger Lake State Park or something.
And what type of improvements could be done with that amount of money, in your judgment?
There was some discussion that eventually they might build a nature center or some kind of a training center, or you could always build shelters or do work on the shooting range, or whatever amenities are there. It could be improved or maintained.
Okay. You testified that the chief concerns that your department had regarding the issuance of this permit related to view and sound. Is that correct?
Well, and disruption. Hiking is very popular there, so if you close some of the hiking trails temporarily, this would be a disruption. So yeah, the sounds, the forest is serene. So the view shed is important. The sound, the disruption of the hiking or bicycling, those are all things that concerned us.
Have you seen the analysis prepared by the engineering company retained by the permittee as it relates to the view shed, as its impact onto the forest?
No.
Objection, relevance.
He's
Well, I think
testifying as to the view shed.
I understand. Well, there's no evidence in the record that the engineer is competent to assess the view shed.
He's simply asking if he's aware of or has reviewed one. So
I don't remember looking at it. I may have, but I don't remember looking at it.
So you're basing your judgment as to the impact of the view shed on Kanawha State Forest due to the mining activities of my client upon your own personal feelings?
No, I'm basing it on what was brought to me by the chief of parks, the park superintendent, and the district administrator, who are familiar with the park,
I see.
the forest, more so than I. So they evaluated that, and they bring back to me and say, this is, this will impact this. So that's the only knowledge I have of it.
Okay, and would that also be true as it relates to the sound impact upon the park?
Yes, I was never there to listen to
Well,
anything.
you weren't there when current mining
No.
activity's been going on?
No.
And by giving the department's approval to this permit, you are satisfied as to those concerns and the other concerns that you've testified here today, that they are properly remediated to your department's satisfaction. Is that correct?
We believe that through those concessions or changes or whatever, that they would be either minimized or mitigated to the point where it would be a temporary inconvenience for the park users, and based on that, we agreed.
I have just one last question. In Exhibit 10, which was presented to you earlier, it is a DEP document that's page 325 of the certified record. That particular document is, and I'm simply referencing it, it states that it's document G1, affected public-owned park information. Do you see that?
Exhibit 10, G1?
Yes.
Yes.
You see where it says affected public-owned park information?
Yes.
Okay, and that appears to conflict with the statement below, will any publicly owned parks be affected by the proposed operation? Do you agree that that appears to conflict with that statement?
Yes.
So it appears that perhaps it was simply a typographical error.
It conflicts.
Objection, speculation.
It conflicts.
That's all the questions
Yeah.
I have.
Okay, yeah, we'll uphold that. Mr. Jones?
I don't believe I have any questions. Thank you.
Mr. DiPaolo?
I've got some follow-up.
Oh, okay.
First of all, I guess I'll start with what was asked last. Is that the certified record that I can present to the witness that's there?
Yeah.
Okay, back there, thanks. Thought you were telling me to leave. You were just asked, sir, whether you think a typographical error was made by the permittee in submitting an application that refuses to state that this is a publicly owned park, correct?
Yes.
Let me hand you what in the certified record is page 198, and I'm gonna wait for just a minute, so if you folks wanna pull that out, I obviously don't have copies.
Tell us what it is.
Can you explain what it
Just
is?
show us what it is, if you would.
It's page 198, I mean.
Okay, then give
if
me
you want
10
to-
minutes to pull it out. If you show it to me, I probably have seen it before, and I'll let you ask him the question.
Please. Sorry, I thought you guys had it all sitting there.
I do, it's in a box here. It's- Okay, that's fine.
Yep.
That's fine.
Mr. Jones, you want to look at that page? You're all right. Okay. Let me show you what's in the certified record on page 198. Do you see where in this section it has identified parks and recreational facilities?
Yes.
Underneath it, it says Part G, parks, recreation, and conservation areas and facilities including tourism. And the question here is, will any parks, recreation, or conservation areas or facilities including tourism be acquired, relocated, or removed by the anticipated surface mining operations? Do you see where I read that?
Yes.
How did the permittee answer that?
No is checked.
And then underneath it, it even has an area where they could have identified an area by facility name, type of area, nature of impact, and mitigation actions. Is that correct?
Correct.
And those are all blank, is that right?
Correct.
Sir, what did the West Virginia DNR do specifically to evaluate impacts to the park?
Again, the park superintendent.
Objection, I think we've been down this road. I think he's asked that question and the witness has answered it through Mr. DiPaolo's question.
And I'll ask some more specific questions about it.
Please.
Did you guys hire any experts to examine the effects to the park?
Not that I'm aware of.
Did you discuss the effects on the park with the Kanawha State Forest Foundation?
I personally didn't.
Do you know if anyone at the DNR did?
If there may have been a meeting, again, with the district administrator or parks chief, I'm just not perfectly sure.
Did you examine the comments from the public that were made on this permit?
I don't remember seeing the public comments.
And if I can have you look at Exhibit 5. On page 2, in the first paragraph. And I understand you get a lot of information in your office. And I'm sorry, it's Dr. Gizzero, I didn't realize.
No, it's not.
Oh, okay.
No.
Mr. Gizzero, okay, I don't want to call you the wrong
No,
thing.
it's Frank Jezero, just
Thank
plain
you.
Frank. That's what my mother
Frank
called me.
Jezero.
Yeah.
All right. The last sentence of that first paragraph says that you provided the parks with copies of some 180 comments received by your agency. Is that right?
Yes.
Does that refresh your recollection that the DNR would have examined some of those comments?
Yes.
And
The
in
question,
this-
I think, was, did I see him?
Okay.
Yeah,
right, fair enough.
and no, but yeah, apparently we did receive them, and again, they would have been reviewed by our chief of parks and the people who are involved daily in that operation, yes.
And I'm sorry, I'm saying you as if you're the DNR and you're answering directly as if it's you. That was a bad question. But this notes that all 180 comments were opposed to the permit. Is that right?
Correct.
Do you have any knowledge as to whether there was any comments returned on the permit that said, yes, please do this?
Not to my knowledge, no.
And what was cited in the comments was that there's environmental concerns, destruction of views, and negative local economic impact. Is that right?
Yes.
Did you hire anyone to look at the economic impact of the mining beside the park?
Not that I'm aware of, no.
And I'm saying you, I mean the DNR.
Not that I'm aware of that. I don't remember any discussions with my people saying that we hired a consultant and they said it would do this, that, or whatever. No.
Thank you, sir. I don't have any other questions.
Just briefly. Sir, in response to, I think, a question from Mr. Hoyer, you stated that your impression was that the damages or impacts of the mining operation were going to be, there had been some modifications made and that they were, in any event, temporary.
Yes.
Are you operating under the impression that at the end of 10 years, somebody's going to go put a mountain back there that has disappeared in the intervening decade?
Objection.
Can you rephrase the question maybe to ask him
If as a result
impression
of the
is?
surface mining, the mountain that is presently there disappears, is it your impression that somebody is going to come back with a brand-new mountain put in
Objection.
its place?
Let's,
That's a simple enough question. He can answer that, yes or no.
It's a
No.
rather complex question, it's inaccurate as well.
Well, I'll grant you, it's more complex than C-spot.
well,
run.
not as an expert, obviously, maybe he can't testify as to what's going to happen in the permit. I don't think it's a problem if he wants to give us his impression of what the mining before and after process would be, if he has one that he wants to offer.
No, I don't envision somebody bringing another mountain. Probably the people where you would take the mountain would be upset. What I envision is, they said they would reforest that section and reforest it with hardwood timber, but the mountain obviously will not be brought back.
Nothing further.
I have nothing further.
I have one further. Are you aware of the concept of approximate original contour? Do you know what that term means as it relates to surface mining?
Yes.
Are you also, would you agree with me also that this permit requires that the mining be conducted in such a manner as to return the property to the approximate original contour?
Objection, there's no foundation for that.
Well, it's the same
permit.
situation as you had asked him. We're trying to understand what his impression is of the situation, not that if he doesn't know, or if he doesn't have an impression, he can tell us, but we're interested in what the agency and the public perception is.
My perception from past experience, reading, or whatever, is that most, if not all, surface mining permits require that the contour be restored as close to natural as it was prior to the mining. That's my understanding, is that there is some provision that says you have to return the land to the approximate contour. That's now, specifically, if you remove something, I don't know, but that's my understanding.
I have no further questions.
Just a minute, Mr. Jones, do you have anything?
I have none.
Have you ever been to a mountaintop removal site?
No.
Okay, no further questions.
Any further questions from anyone? What about the board? Does the board have any questions? Go ahead, Mr.
Yeah. This is something you haven't gotten into, Frank, but one of the requirements in the regulation is on endangered species. And that talks about plants and
Sure.
animals and such, and there's been some information given to us in the documentation about problems with bats, possible problems with bats.
Right.
Did you folks look into any of that?
I'm not sure if that was done by our people or by DEP, but I saw that reference, and I'm just assuming that somebody, I don't remember discussing it personally with our wildlife people. I'm assuming that DEP possibly looked into that, but I don't remember personally looking into it.
Okay.
But I did see that referenced.
In your opinion, would the blasting possibly have a negative impact on the birds and the bat?
Depending on where the blasting was in relation to bats, if they were there, I would I would, assume that it might, but I just don't know. I don't have enough expertise there to really know.
Well, one section in here, you state that the permit area could possibly be within 300 feet of your firing range
Yes,
that you have there.
yes.
If there were blasts going off close to 300 feet, would that scare away birds and bats, and you think?
Oh, I would think that it would, yes.
Okay. Thank you.
Any other questions? I have one question, if I
Sure.
can ask it. If you can answer this, if you put yourself imagine the situation where everything had happened as it has, and all the documentation had been the same, but the 10 cents per ton had never been mentioned to you or offered to you. Do you think that would have changed DNR's or your approval of the permit?
No, not at all.
That's all I have. Nothing else, then I guess you're excused. Thank you.
We have no other witnesses, we would rest.
All right. And I guess we're ready to go forward, Mr. Wan.
Well, beforehand, I'd like to make a motion for directed verdict on both of the appeals, and I can make it brief, just so the record's clear.
Okay.
It's our opinion that both sets of appellants have failed to carry the day or to provide any kind of affirmative evidence that proves any of the issues raised in either of their appeals. First, with regard to the allegations about the SWARA, we acknowledge there was an error, we corrected it, a revision's been calculated and submitted and approved, so that issue's mooted. Second, the issue with regard to SHPO has been briefed by both sides extensively, and it's clear that there is no adverse effect on the Kanawha State Forest, as just exemplified by Director Jezero's testimony, for instance. Therefore, SHPO approval is not required at all, and even if it were technically considered to be required, it was obtained with regard to the archaeological resources and by their own silence with regard to the architectural issues. And lastly, with regard to the Endangered Species Act, they've presented no evidence that DEP has failed to perform its duties with regard to either the Indiana bat or the proposed northern long-eared bat. The evidence in the record shows completely that DEP has complied with all regulations that require protection of the Indiana bat, and with all regulations and discussions with Fish and Wildlife Service regarding protection of a proposed listing of the northern long-eared bat. Lastly, in the Cordell appellant's notice of appeal, there's a vague nuisance claim, which isn't cognizable in this court, a civil claim, and they presented no evidence with regard to the myriad alleged health impacts that would supposedly prevent issuance of the permit, and so those claims should also be dismissed.
I'll be happy to go first. Whatever,
Well, we were gonna join, but he can go first.
Well, do you join? Do you have anything to add to his
Well, the
thing?
only
Let's
thing we
get
have-
this side out.
Yeah.
that's fine.
The only thing that I have to add, and we filed a brief on this, I don't think there's no factual issue. We're left here with legal issues, and I think that the legal issues favor the issuance of the permit. The board's charge here is, after considering the substantial evidence in the record as a whole, was the DEP's decision to issue the permit, was it clearly wrong? That hasn't been established. Was it arbitrary? That has not been established. Was it capricious? That hasn't been established. And was it characterized by an abuse of discretion? I don't think, under that standard, which is the standard, the appellants haven't carried the day, and that's why we joined in the motion with the DEP.
And I'd just like to add, we're prepared to offer essentially rebuttal testimony today, but there's nothing that we have to present that isn't already contained in the certified record that stands before you today.
Okay.
I would just like to point out in joining in the motion that in the wrist exhibit number 6, that was presented by Mr. Riss to the board and to the witness. On the second page, starting in the third line, it states that the position taken by DEP is that the federal interpretation of adversely affect appears to give the state agencies a great deal of discretion in determining whether adverse effects have been sufficiently minimized to allow permit approval. I would respectfully submit that Mr. Smith has stated to you that the standard which the appellants must carry, that there has to be some clearly wrong or capricious or some other problem other than the ordinary exercise of discretion. I believe in this case what you're going to find, regardless of whether it's a park or not a park, that DNR manages the forest. They have given its approval in the exercise of its discretion with which they have latitude, after there were great changes made to minimize the effects of the permit on the forest. DEP also has that discretion. They have exercised it, and there has been nothing presented in the evidence to this board that says in any way this is arbitrary or capricious or otherwise they have abused that discretion. So I would join in the motion and urge the board to grant.
Mr. DiPaolo, would you like to respond?
Well, briefly, and I think that's a useful departure point. The reference to the broad discretion that DNR possessed in deciding that the project did or did not have an adverse effect on the publicly owned park. SHPO has the same broad discretion with respect to the assessment of the impact on the Canal State Forest Historic District. And although the gentleman testified that he thought that the changes dealt with his concerns, he's got no demonstrable expertise, in fact none whatsoever, demonstrated with respect to the assessment of the impact on historic sites or places. That jurisdiction is committed exclusively to the West Virginia State Historic Preservation Office. And the claim here that they have exercised, remained silent is based upon what I have called it's the we'll keep the lights on for you defense. In other words, because we wrote you this letter telling you to take a hike on May 1st, and we'll keep the lights on for you though till May 31st to see if you do anything. Fact is they didn't. They went ahead and issued the permit. So the notion that there's undisputed facts relating to their silence, they weren't silent. The late November 6, 2013 letter was very clear on the adverse impacts on architectural issues. That was reaffirmed explicitly in February 20th, 2014, the letter from from SHPO to DEP. So the suggestion that they were silent or hadn't consented or effectively consented to it is simply not supported by the record. With respect to the ESA, the Endangered Species Act issues, so there's no question the DEP claims that they had conformed with all their duties. With respect to the Indiana bat, the underlying survey was conducted on June 21st, 2009. That expired on June 21st, 2014. They do not have a current bat survey in place. And if, as I contend, SHPO approval was required, supported, of course, only by the statute that says it's got to be joint, then the issuance of a permit on May 5th in no way stop the running of the clock with respect to the Indiana bat. With respect to the northern long-eared bat, all duties were fulfilled. Well, the requirement in the guidance document from the Department of Interior is that they consult, and that's also the consult with the U.S. FNW, and that's also the requirement of Title 38 of the Code of State Regulations. The sole matter asserted that constituting this consultation by DEP with the DOI is a statement by DOP's counsel that they read the interim guidance document. Well, I mean, you know, that's creative. I mean, the lawyer has to dance with what he brought. That's all he had, and I'm suggesting to you that it's less than paper thin. The SWARA analysis, we were advised after the fact that it was approved on July 21st. We were never served a copy of the proposed changes in advance of learning that it had already been submitted and approved. To the extent that that's a central part of the permit, and it clearly is, there's been no opportunity for comment by the public as required by law. So I think there are plenty of reasons why they should, their request for a directed verdict should be denied.
Mr. Rist?
Thank you. A couple of things, really with the SWARA analysis as well, that was an issue that was brought up by the appellants jointly. And after we brought that up, it was resolved. And so, I mean, that's an issue that was favorable to us, I believe, or it definitely was. The second thing I'm looking at here is we had testimony, if the board remembers, from Henry Fred Thomas, who came in, 40 or 50-year resident of Loudondale, and he's worried about his water quality, as he should be. That was something we put evidence on. It's factual. We believe the groundwater inventory baseline testing did not include potential contaminants of concern. He's concerned about his water, and I think from the flip side, that factually we should hear what's going to be done to protect this source of water for these residents that live below this permit. All right. Third, the blasting notice in this case is wholly inadequate. I mean, based on what the permit is, and my understanding is that blasting is happening already. And what's been given is a very generic, hey, we're going to blast between this date and this date a whole year. Even the permit face that's marked there has limitation to it, but that's not been done, and the residents haven't been given that. And so factually, I want to hear from that side what's being done or has been done to respond to that. Dovetailing into this, portions of the operation are going to require the temporary closure of public road leading to the shooting range, trails in the park, and other things that were testified to by everyone, including the head of the DNR. That dovetails into the blasting issue, because when's that going to happen? Is it going to just be generic? Are we going to have a heads up, or is the public going to know when they're going to this park when that's going to happen? And I think based on the permit face, that something more specific needs to be done. That's a factual issue. Next, and last, the issue I'll bring up last, and really it's a strange issue to say the least. The permit states without question that no publicly owned park will be affected by the proposed operation. Right? And that exchange that just happened, and the reason that Mr. Jezero came in and testified is because there's a great effect to this park that's occurring. They've gone to great lengths to talk to him about it. They've gone to great lengths to get the DNR to give an approval and look at that, yet the coal company's saying that that's not what's going to happen. There's no effects to this park. They checked, no, it's not a typographical error. It appears in two places. If it's a typographical error, that's a question of fact. We need to talk to whoever it is that was putting the permit together. Because what happened because of what they're dubbing a typographical error, section G1 of the permit doesn't exist. It doesn't exist, because when you check no, you don't have to do the rest of that section. And because of that, the people that we represent, in this case, the appellants and the citizens of West Virginia, didn't have the opportunity to even comment on these issues because it didn't exist. That is a factual question. We need to hear the other side of it. Because if that's a typographical error, this needs to go back and be changed. We believe that we've established surely enough to go forward on these issues, and would ask the board to deny the motions that have been made. Thank you.
Mr. Wallace?
Just as a matter of rebuttal.
Sure.
I'll take the points backwards. As Mr. Rist noted, the 10-G Parks and Recreational Facilities section states, will any parks, recreation, or conservation areas or facilities, including tourism, be acquired, relocated, or removed by the anticipated surface mining operations? The answer is no, because no areas or facilities are going to be acquired, relocated, or removed, period. With regard to statutes cited requiring with the roads, that's for closure of the roads. No roads are going to be closed during this issue, during this permit life. Mr. Riss noted that one of his clients is worried about water quality, but that's understandable, and I appreciate his concerns, but it's up to the appellants to prove affirmative evidence that that's actually occurring, not just a sort of fear or concern. That's simply not enough under our rules.
Mr. Chairman, if I might,
Wait, let's let him finish.
are you finished?
No. Mr. DiPaolo repeatedly misstates the facts when he refers to the area adjacent to the mine as the Kanawha State Forest Historical District. It's not on the National Register of Historic Places. It's nominated, but that's simply not enough. The appellants have not shown the evidence of any potential adverse effects on any areas within the forest, and absolutely with certainty nothing that's on the National Register that requires the approval we're talking about. You know, in general, the council constantly allies to the fact that there's just no evidence whatsoever of an architectural and adverse impact here. They presented no testimony that any of the structures listed in the nomination, for instance, to the National Register, are going to be affected. Not the forest superintendent's house, and not the two shelters at issue that are just nominated, period. There's no evidence. And for that reason, we should be granted directed verdict.
You have any other?
Just briefly, the appellants have said that SHPO joint approval is required by the statute. Not any statute that I've seen, and not any statute that the board's seen. The dovetailing the bat situation and the SHPO, they're not here. Fish and Wildlife is not here. They had concerns about the bats, they'd be here. They're not here. SHPO's not here. And the appellants aren't the proxies of SHPO, and they're not the proxies of the federal Fish and Wildlife people. If those were real concerns, I'm sure those agencies would be here.
Mr. Jones? You have anything you'd like to add?
Sure. Just briefly, the historic district was added to the National Register in April of 1993, and the documents authenticating that fact were admitted into evidence at the last hearing. The question of whether or not some portion of the park, which includes the view shed, is going to be removed, it is. The mountain next door is going to be removed. That's part of the view shed. The question of Fish and Wildlife being concerned or not here, whether the council knows it or not, it's the policy since 1951 of the Department of Interior not to allow its witnesses to be subpoenaed. There's a whole set of regulations called the Toulouse regulations that present basically insurmountable barriers to getting Fish and Wildlife to appear in any proceeding in which they're not a party. And the question of SHPO not being here, frankly, that's their problem. They've got to.
That's a misstatement of law.
That's the requirement of 22D, 22.3, 22D2 is to
Let him go.
get joint approval of anything that affects the historic district. In this case, the DEP made that finding when it required the permittee to fill out the form called MR-SHPO, which is the form that is sent to the applicant. Very, very extensive information is collected. DEP made that finding. Once that finding is made and the applicant is required to fill out the MR-SHPO filing, DEP no longer has the right to come back and say, oh, well, we disagree with your assessment of the impact, and because we disagree with your assessment, we're now going to go back and revoke our prior finding that it was affected. So, you know, additionally, nobody inside the DEP has satisfies the Department of Interior's standards on professional qualifications to make assessments with respect to the impact on the historic district. There are very, very specific requirements which are a matter of law, which happen to be included in materials submitted, and they're all matters of law which the board is required to take judicial notice of. But items 7 and 8 constitute a summary of those qualifications. Number 8 is the full statement of those qualifications. It requires people to have either advanced degrees in historic preservation or bachelor's degrees in extensive experience. Nobody from DEP has been shown to have that experience. That's why the decision making with respect to it is vested exclusively with SHPO. DEP crossed the bridge, giving away any jurisdiction over that when it sent out the MR SHPO form and required the applicant to
Same
fill it out.
objection.
Okay. Mr. Riss, do you have anything to add here?
I made my argument, thank you.
Nothing.
Long, Mr. Jones?
Nothing at this time.
Okay, we've been in this for a while. Let's take a break if we could. Let the board talk about this a little bit. We'll get
Thank you.
right back. This motion, and we're going to reserve ruling on it and ask the DEP and the interveners to go ahead and present their case. And a short reasoning behind that is that there are some details that the board, and I would imagine the public, are interested in how decisions were arrived at and what consideration was given to decisions. And so maybe in the interest of better informing the board and the public on how the DEP developed their work and how they see their case, we'd like to hear from them if we could. And of course, whatever information the interveners have to add and how the decisions in the permit were made. So we'd like to hear from your side of the case if we could.
Thank you, Chairman. Just a moment, please. We're trying to make a. Well, we'll go to Kevin quick.
Okay.
Quick, could you state your name for the record?
Kevin Quick.
And what's your title here at DEP?
I'm an environmental resource analyst.
Could you describe what you do in that position?
I work with, in conjunction with OSM and in relation to the Appalachian Regional Reforestation Initiative. It's a technique, it's a initiative to restore hardwood forest of value on reclaimed mine sites, and it uses what's called the forestry reclamation approach, which was developed by several scientists in growing trees, quality trees on reclaimed mine sites. And I also work with endangered species consultation program within for mining and reclamation.
Sorry, could you describe your educational background for us?
I have a Bachelor of Science degree in Wildlife Resources Management from West Virginia University.
And did you have occasion to work on the permit that we've been talking about during today and the first day of the hearing in this matter?
I was involved in the endangered species consultation part of the permit.
And what does that mean when you say endangered species consultation?
That is within the regs. It discusses. I don't have the regs with
Oh, it's
me.
okay. You don't have to quote
Yeah,
further,
okay.
just give us your
Just-
idea.
The Fish and Wildlife Resources information will be in the permit. Then I think the next section of the reg says that the scope and level of detail of that information will be determined by the Secretary or the DEP and the agency, the state and federal agencies responsible for fish and wildlife in that particular state, which here would be the West Virginia DNR and the U.S. Fish and Wildlife Service.
And with connection to this permit, which species were you concerned about specifically? Was there a bat species?
Specifically, originally in the permit process, the Indiana bat.
And is the Indiana bat listed on the endangered species list?
Yes, it is.
And because it's listed on the endangered species list, what does that mean when it comes to time to review a permit for approval?
It means we're going to have to address the issue of whether it's on the permitted area, if we're going to impact that species with approval of the mine permit.
Okay. And how do you determine if that's the case?
Well, it's a process. The first step would be to conduct surveys to determine if the bat was using the area, was in the area. We'd
Let me stop you there real quick. How do you do that?
The companies hire a consultant. They go out, they misnet at night. They pick sites, areas where the bats would be likely to be foraging, traveling at night. Put the nets up because the bats come out at night. They're at rest during the day. They put the mist nets up, and then they have the process. They monitor them throughout, the nighttime, and then physically identify the bats that they catch.
And was that done in this instance with regard to the Indiana bat?
On this permit area, it was done twice.
And when, do you remember when it was done?
I don't remember the exact date. The first survey was conducted in 2005. I don't remember the exact date. Probably, well, the netting, there's a netting season as well. I left that out. A survey season, I should say, which runs from May 15th till August 15th. So it would have done within that time frame. I'm not sure the exact time these were, the latter survey I am, but the earlier one I'm not.
And I would refer everyone to page 663 of the certified record. If I told you that bat survey was, I'm sorry, 663. If I told you that survey was conducted June 21 to June 24, 2009, is that your understanding?
That would be the second survey, the latter one that I spoke of, yes.
And then, once you reviewed that survey, did you have a chance to review that survey?
Yes, I did. We captured no endangered bat species. No Indiana bats were captured. Therefore, we were able to approve the consultation, as we determined that that has been through consultation with the Fish and Wildlife Service. That is deemed as sufficient to determine that the bats are not using the area.
And you sent a letter to the permittee in September of 2009 reflecting that?
Yes.
And how long, so to speak, does that approval last?
5 years from the date of survey.
Okay, and again, the survey was completed on June 24th, 2009, correct?
Yes. It began on 21st and was completed on 24th.
And so as we've come closer to when the permit is issued, you've heard testimony about the potential listing of another bat species. Is that accurate?
Yes, the northern long-eared bat.
Okay. Is the northern long-eared bat currently listed on the endangered species list?
No, it is not.
Was it set to be listed this year?
Yes, I'll elaborate if.
Please.
Okay. Yeah, we found out in October of 2013 that the northern long-eared bat was going through the process, proposed to be listed. It's a process it goes through before it's officially listed as an endangered species. When we learned of this in October, we were concerned about how we should handle the bat in the interim. It's proposed to be listed, the official determination would be made in 12 months. So how do we deal with the permits that we have in that time frame?
And why are you concerned about that?
So it's consultation purposes, we want to keep our consultations complete and up to date.
Because there's a law or rule that requires you consult with the Fish and Wildlife Service?
Yes. So we contacted Fish and Wildlife, and they're a very, very busy group up there, and it's sometimes hard to get direct interchange, but through emails, phone calls, messages, we were directed at the time that since this species was proposed to be listed, we would not be required to address it until it was officially listed in October of 2014 at that time. We requested a meeting with the folks at Fish and Wildlife Service, even though they didn't have to be addressed until October of 2014. We wanted to discuss further how because we have several permits in the permit review process, permits that may be approved and not started. And, how are we going to deal with this new species related to all of the permits in the various stages that we have. Unfortunately, it took a while to get a meeting. It was not until March that we got the meeting. But in the meantime, through email, phone calls, we were told that, again, that we did not have to address this species until it was officially listed, which that did, and, okay.
Okay, let me stop you there. It was originally going to make the list, so to speak, when?
October.
Okay. And
It
is
was
still
12 months from the.
And is it still scheduled to make that list in October 2015?
No, the number of comments that were received by the Fish and Wildlife Service were tremendous, and so in order for them to review all the comments related to the listing of that species, they pushed that date back, and now I believe the date is April, sometime in April of 2015. So it will not be officially listed until if it is officially listed until that time.
One moment, please. I've got to get my paperwork on this.
Thank you, sir.
I'm going to hand you a document as soon as I can get out of my nest. If I might approach. This is a document called the Northern Long-Eared Bat Interim Conference and Planning Guide. I have that marked as an exhibit. What is this document, sir?
This was a document provided to my agency, and I'm sure other agencies and groups, individuals concerned with the northern long-eared bat.
Can you do me a favor and speak up a little bit?
Oh, I'm sorry. It was produced by the U.S. Fish and Wildlife Service, and it's interim conference and planning guidance for the northern long-eared bat.
And if you can, and what does this document really do?
This gives guidance to those dealing with the Indiana bat as to how to consult related to the bat and other issues related to the bat.
And when you just said Indiana bat, are you sure?
Oh, I'm sorry, northern long-eared bat.
Okay, we have to make sure we keep our bats separate.
Yes, I'm sorry.
Yeah, it is an important distinction because one of them is
Yeah, right.
immediately protected and the other we're not quite so sure yet, correct?
Yes.
Now, on page 6, if you turn to page 6, under the section headed Conferencing for NLEB, and that's the acronym for Northern Long-Eared Bat, and the Jeopardy analysis, what does that section tell you? What's your understanding of what that section means?
That there's no prohibition for taking proposed species.
Okay, what does taking mean in this context?
Take would be if you were to harm, harass, or kill our northern long-eared bat.
And when it says that, does it mean in one discrete instance or across a large area? I mean, what does that really mean? If I go out with a BB gun and shoot a northern long-eared bat, is that wearing a DEP uniform? Does that constitute taking?
Objection. There's no foundation. That's a legal conclusion, what it constitutes a taking. There's nothing in his credentials thus far reflects any experience in any determination of taking or any of the other matters that are being inquired into.
Since his department is the one who are dealing with these people, surely they have some type of guidance themselves that they use to comply with this. We'd be interested in knowing what that guidance is, whether it's exactly legally correct or not. We'd like to know how they apply it.
So would that be a taking?
If the species is not listed, it would not be a take.
If it is listed,
It would be a take.
okay. So that's a very specific sort of thing. A taking actually refers to any instance of one specimen of, say, the Indiana bat, for instance.
And endangered, yes.
Okay. And then it says, while there is no prohibition for taking proposed species, there are certain statutory requirements in the ESA for proposed species. Section 7A4, and this is the second paragraph from the bottom, of the ESA states, each federal agency shall confer with the Secretary on any agency action. Now that just applies to federal agencies, right?
That's my understanding.
And the West Virginia Department of Environmental Protection is a state agency, correct?
Yes, and that's in our discussions with the U.S. Fish and Wildlife Service. That's what they relayed to us as well.
Now, as a state agency, what's your understanding of what you have to do with regard to a proposed species?
We would not have to address it until the time at which it was listed, as we were directed by the U.S. Fish and Wildlife Service in Elkins.
Did you, though, have any consultations with the Fish and Wildlife Service?
We had several, as I talked about earlier, we had the, through emails and phone, and we were made aware that this guidance document would be coming out in January. As I said, we had asked to have a meeting and discuss how we were going to deal with the northern long-eared bat in our consultation. Then in March of 2014, after this document came out, we had a meeting. We'd read this document. We again posed.
Let me stop you there. The meeting was scheduled for what date in March?
March the 4th.
Okay, and it was to be held, bless you, it was to be held where?
We were to meet in Elkins on March the 3rd, but due to weather conditions, I think the state even called off work on March the 3rd. So on March the 4th, well, through phone conversation, email on the 3rd with the folks up at Elkins, we decided to teleconference on March the 4th.
And who attended the teleconference?
There was some of my colleagues with the DEP, Lewis Halstead, Ben Lohman, Christopher Harvey. Ben, Chris, and I work with the endangered species consultations. And
Who was on the phone from Fish and Wildlife?
from the Fish and Wildlife was Barbara Douglas and John Schmidt.
And that's SCHMIDT, right?
Correct.
Okay. And what did you discuss? I know there are many issues on the table for that meeting. What did you discuss with regard to the northern long-eared bat?
We specifically again asked the question, in regard to consultation for permits that were in the process, not approved or not, what would we need to do to consider consultation complete for anything, northern long-eared bats related to permits. And we were told again that you do not have to address this species until it is listed. They referred us to this guidance, which we'd been referred to earlier, that they did not need to be addressed until the species was listed.
And after that meeting, did you have any other communication with anyone at Fish and Wildlife?
There was another communication, an email. A question was posed specifically to this permit, and I can't recall the date.
It was April 16th?
April 6th, yes, I think it was April 16th. It was April 16th. There was exchange related particularly to this permit. It was asked if there were any Indiana bats captured during the surveys, and the answer was no. It was asked if it was with any of the radii, protective zones, termed as radii, in relation to previous captures or known of Indiana bats, and we said no, we had no information to that effect.
Was that, who initiated that conversation?
That was Barbara Douglas
At
U.S. Fish and Wildlife Service.
And do you know what precipitated her to ask the question in the first place?
It was related to a letter she received from the Keepers of the Mountain Foundation.
Some of the appellants in this case, for instance.
Yes.
And if Bill DiPaolo, their lawyer, is the one who initiated that for the Friends, or the Keepers, is that accurate?
I'm seeing a copy of that letter, and yes.
I mean, I'm all for a couple of leading questions, especially on trivial stuff. I don't think you ought to use a leading question on every single solitary matter,
Well,
especially
ask
when
you
it
to
gets to
try
the
and
substance of the stuff.
I understand
mean,
your concern.
He's an adult. I'm sure he can answer a question.
I understand. Well, that's happening on both sides to all parties. We'll try to minimize that if we can, please.
Was she satisfied with your response? To your knowledge?
Yes. To my knowledge, she was satisfied. There was no...
When she responded, did she have any follow-up questions she either emailed to you or called you about?
We never received any negative, anything opposed to the permit or or any recommendations that our consultation was not satisfactory.
So there was no change to the permit required with regard to the Indiana bat, is that accurate?
That's accurate.
And was there a change required with regard to the northern long-eared bat?
No, no.
If the northern long-eared bat makes the list, what happens at that point?
At that point, it will have to be addressed by any permits that have capture records of northern long-eared bats.
With regard to this permit that we're talking about today, will there be any further requirements placed, to your knowledge, on the permittee?
Yeah, I think there were captures of northern long-eareds in the bat survey, so yes, it would require a PEP. The guidance and.
Sorry, let me stop you real
Okay.
quick, because we're trying to assume that we're talking to people who may not completely understand a lot of this stuff. What's
Okay.
a PEP?
It is a protection and enhancement plan
What does that do?
that provides measures that will protect and measures that will enhance the habitat for the particular species it is written for.
But that's just for a species that is on the endangered species list, right?
Correct. I don't know of protection enhancement plan being required for anything but endangered species.
Now, there are other issues that have come up during this appeal hearing with regard to the appearance of birds on this site post-mining. Do you recall Mr. Doug Wood's testimony about that?
Oh, I think that was in reference to a letter that the appellants had written to the director of the DEP, and then there was a response. I believe it's part of the record.
Let me see if I can find it. It's on page 171 of the first installment of Mr. DiPaolo's proposed exhibits. I'm going to show you this.
Okay.
I might approach again.
Yes, this letter. There was a letter sent to the DEP, and then Mr. Ward, our director, and then we responded.
Can you tell us the page number? It's the bottom right.
Page 171.
This is volume 1, correct, of the exhibits?
Yes, sir.
Yep.
And did you take issue with any of Mr. Wood's characterizations about the bird species with regard to the post-mining use of this property?
Yes, that information is found on page 175 under a heading of forests. The response that we wrote back, I thought during Mr. Wood's testimony, I thought he took it somewhat out of context as relation to species that may benefit. I think the wording of the letter states that there were species listed as species of greatest need of concern, something that was discussed by the appellants. And in our letter, we stated that there were species that could potentially benefit from the mine.
Could we ask the witness to identify what he's reading from? What paragraph?
Paragraph 3, page 175.
What are those species?
The species we listed were dick sissel, henlow sparrow, northern harrier, eastern meadowlark, bobolink, goldwing warbler, grasshopper sparrow, horned lark.
And do you have any justification for believing that those species would actually appear on the permitted area after mining?
Yes, as we told in the letter, it's documented that these species have inhabited reclaimed mine lands. There's many articles in magazines, Ohio Wildlife, Kentucky Wildlife. There's research projects done in in various states, including West Virginia, and some done in northern West Virginia, and one in particular that was done in southern West Virginia.
Could you identify that, please?
It's the Mountaintop Removal Mining and Valley Fill Environmental Impact Statement Technical Study, Project Report for Terrestrial Studies.
And what does that document purport to do?
It
Is this a
reports-
document that's already in evidence?
No.
Okay, do we, if he's, before we let him testify,
I'm not
From-
moving for its admission into evidence.
before we let him testify from it, though, we need to have a right to see the document? I mean, he can't testify from a document that's not in evidence.
He's not, he's not gonna testify out of it.
He's not going to use it as a reference, but, I mean, is he going to explain to us what it is generally? And
Is he
where
going to
where it
purport to
gets from?
summarize it? It needs to be admitted. It's, everything he's saying then is hearsay. So what's the let's see the document.
Would you like to see it? I can see it.
Yeah.
I didn't
good.
want to kill any more trees. 1 second, please. Can you actually point out where you're going to talk about?
Oh, yeah, this one. This.
I'll take it later. I think I do this. Let's just, let me ask her a question.
Okay.
That article we were just discussing rather, that's a study about which bird species appear on mountaintop removal sites after mining.
It was a study conducted in 1999 and 2000 by Pitcher Bohall Wood.
Okay, hold it, just, let's stop. It's like.
I'm not going to ask him any other questions.
He's not,
Dr.
I assume he's not going to testify straight out of what the study says. He's just stating what it is.
In your experience, in your area, the songbirds, the birds listed in the letter you were testifying about, those do appear on sites like we're talking about in the permitted area after mining use. Is that correct?
Yes, they've been documented on mines in Boone, Kanawha, and Logan counties.
And that's the Dick Sissel.
The Dick Sissel has been documented, the Bobolink has been documented.
Okay,
The
look, I'm gonna
sparrow.
object here, if the documentation is in fact the materials he's just referred to, which are highly highlighted in yellow with tabs on the thing and clearly have been reviewed, if that's the basis for his documentation, I object to the testimony.
I asked based on his experience.
No, yeah, well, the testimony was that it was documented.
Well, he's answering based upon his experience then? Is
Yes,
that the
sir.
question?
Well-
And not upon any particular document?
Yes.
Let's let him answer then, understanding that it's based on his experience.
And I think you've given us your answer. I don't have any other questions for you. Thank you.
Cross, what experience are you referring to?
I was a mine inspector for 10 years. On my mine inspections, I saw northern harriers practically every mine site in the state that I've been to.
Okay. Do you still have the volume of exhibits that was handed to you earlier?
Mhm.
Would you turn to page 177, please?
Mhm.
Okay, you see the, let me, for the benefit of the board, I'm pointing to the exhibit 22. Do you see these somewhat large black dots to the
Yeah.
right?
Yeah.
Do you understand that, and if you look at the code at the bottom, see the dark square says confirm, and I believe that's a key that translates the information above.
And actually, real quick before you refer into it, I'd like to reiterate our objection to the exhibits contained that he's referring to that followed Mr. Ward's letter. We didn't believe any foundation was given for their provenance, their origin, why they were created, when, how, or whatever.
And they were admitted into evidence.
Well, yeah, and the board gives weight to the basis, the foundation for these things. And let's let him ask the question, and it, we'll assign weight to it. We understand your objection.
Okay, I think you stated Mr. Wood's testimony was out of context. Is that, did I understand that correctly to be your testimony?
I don't know if that was my exact terminology, but
Well, is that what you think? You think he testified, his testimony took your comments out of context?
Objection, if we
Yeah.
could, we could read the transcript back.
Yeah, do we need to read the transcript, or can we ask
No,
the
I'm
question?
asking, I'm just asking.
I don't remember.
Okay, you don't remember saying
No,
that, okay.
I don't remember what I said.
Okay, well, do you understand what the suggestion that Mr. Wood had about, with respect to Exhibit 22, pointing to it, suggesting that the suggestion in your section of the paragraph relating to forest, that their species is gonna benefit from it, was indicated that his suggestion was that all those species are only found in really very substantially to the east of the site here, correct? Did you understand that?
I understood that.
Okay, and did you understand, on page 178, you look at the next page, again, that the darker dots indicated that the confirmed findings of that particular species were in areas not close to this particular mine site. Did you understand that?
Yes, I understand.
Okay, and did you understand on page 179, again, with respect to the Henslow's sparrow, that the large dark black dots in Wheeling and Morgantown and around Winchester and down at the George Washington National Forest, again, the benefits to those people did not, or those species did not appear to affect this particular mine site. Did you understand that?
Yes.
Okay. The golden winged warbler, page 180. You see all of the dots far to the southeast of Charleston. Did you understand Mr. Wood's comments to be that absent evidence that those species were present at the KD2 mine site, it was unlikely that they would benefit from it? Did you understand that?
Understood his opinion.
Yeah. And you understood the basis for it, did you not?
I understand. Yes.
Okay. And again, on page 181 with respect to the northern Harrier, again, you understood that the one incident of the confirmed presence in the Monongahela National Forest, very substantially east of Charleston and the proposed mine site. You understood that was his basis for suggesting that the purported benefits in the letter that you read from relating to forest were specious. You understood that, right?
Object, that's argumentative.
No, it's describing Mr. Wood's testimony.
Did he use the word specious?
No, I think we understand, though.
You understand the question too, don't you?
I understand that he stated that these would not,
Okay.
it would be impossible, if I remember correctly, for these species to be found here.
Okay. Who trained you when you joined the DEP?
Who trained me?
Yes.
Yeah, could we have I'd like to have some sort of narrowing down, training in what?
In your job.
Are we
In your
going
job.
somewhere? Can you be more specific with your question? I mean,
Yeah.
as to what you're trying to
Okay,
do?
let me make it simple. Did Doug Wood train you?
No,
Never?
no.
Are you aware that Keepers of the Mountains Foundation submitted an FOIA request to the DEP soliciting documents that recorded any and all consultations between DEP and U.S. Fish and Wildlife with respect to the northern long-eared bat?
I was aware there was a FOIA, yes.
Okay. Did the people conducting the search for the documents responsive to that FOIA request ask you for any documents that you had that were potentially responsive?
I think so, yes.
Did you turn over to them the many, many emails and documents that you've referred to today but not actually produced?
Those emails were.
Yeah, I'll object here. He's not the FOIA custodian or anyone who does FOIA
Question was, did he
reporting.
turn
Let me
it over?
finish, please. Or any kind of FOIA reporting or responses to requests.
That objection has nothing to do with my question.
Well, let's let him answer whether he knows whether he turned anything over in a direct response to a FOIA, however else the FOIA was done.
I turned whatever I had in.
Did you turn over the documents you just described?
This document? The Northern Long-eared Bat Interim
No,
Conference and Planning
the
Guide? Yes.
documents relating to consultation between U.S. Fish and Wildlife.
I turned over all the documents I had.
I think you, in your direct testimony, you stated that after, that there in fact was an email on April 16th, that dealt specifically with the question of the appropriate response to NLEB in the context of this particular permit, correct?
Mm-hmm.
And that was,
Yes.
that was an email to you from Barbara Douglas of the U.S. Fish and Wildlife, correct?
Incorrect.
Okay, who was it from?
Who was it from? It was from Barbara Douglas.
Pardon me?
It was from Barbara Douglas.
Okay. I thought that's what I asked, but, and
Yeah.
if I understood your testimony, it was that she was satisfied.
Yeah,
Okay.
there was no
And-
response.
And
otherwise.
that you never got anything negative, correct?
Greg, I never received any emails that,
Okay. Are you aware that she took the communication from Keepers of the Mountain Foundation and sent it to the OSM as a complaint, and that the OSM sent a 10-day notice
Yeah,
letter?
objection, I don't believe that's actually how that occurred.
Well, yeah, I think you need to get some foundation for it. I mean,
Well, there is
If
foundation.
he knows he has any knowledge, he can provide it.
Well, I'm asking if if he's aware of that. That's the
He's
question.
also
As-
he's also mischaracterizing the way the OSM received it.
Yeah, you know,
No,
can you
that's,
make
that's,
your
that's
question-
totally incorrect. The documents are in the file. The documents are in the record.
I would note it's not a complaint at all, and that's the basis of the objection. We join in that objection.
Rephrase that
I'll
if you would.
rephrase.
and-
Are you aware that Barbara Douglas collected the communications from me and DEP and and forwarded them to OSM? Are you aware of that?
I'm aware there was a 10-day notice from
Okay.
OSM.
Do you consider a 10-day notice something negative or something positive?
Depends on the 10-day notice.
Okay, and what do you think about this one?
I think it was incorrect.
And it was incorrect because it was negative, correct?
Objection.
It was incorrect
Yeah,
because we had consulted.
Okay, well, to the extent that the 10-day notice related that you failed to consult, that was the part that was negative.
And that's
Or
the
it was
opinion of
incorrect.
the OSM.
That was incorrect. Pardon me?
That's the opinion of the OSM.
Well, but if their opinion was negative, then in fact, you did get something negative, didn't you? Well, the record will reflect that he shrugged his
yeah, let him
shoulders.
let him
and
answer so we can hear.
I want to suggest we try the English language, yes or no.
Objection.
Didn't you in fact get something negative?
Objection.
We got
to
an
he's
inquiry
asking.
as to whether we consulted with Fish and Wildlife Service, to which we responded, yes, we did consult with Fish and Wildlife
Okay.
Service. Here's the information.
You didn't consider that inquiry negative.
Objection asked and answered.
I
And
considered
counsel
it
is
inquisitive.
conflating. One moment, please. OSM with Fish and Wildlife.
Yeah, what are you trying to establish here, Mr. DePaul?
Well, I mean, as portrayed by him, everything's golden. Everything's coming up roses. Nobody said anything bad. They got a 10-day notice of a complaint.
Well, has he not answered your question sufficiently, or is he just
He's
not?
shrugged his shoulders. That's what he's done on the record.
Well,
I
I object to that characterization.
Yeah.
That's not
It's
accurate
not,
at all.
it's a totally accurate, and the court, the board sat here and watched
Yeah.
him shrug his shoulders.
are you unclear as to what his answer is then?
I think his answer is totally disingenuous, and I think the board is probably aware of that.
I'll object to that
Yeah.
characterization.
Do you feel you need any clearer answer from him? But
I
let's
think
let his answer stand as he makes it.
Candidly, I think his answers are totally clear, yes. And I'm willing to move on to other
Let's do
floors.
then. Okay.
The species that you identified in that paragraph on forest that were potential beneficiaries, do you have any evidence that they're found anywhere in Kanawha County?
Yes, there's documentation.
What documentation?
The documentation that was disallowed.
Are you talking about this material to your left?
Yeah. Also, I've personally seen several of those species.
Okay, my approach, could I have the document? I mean, the question from his counsel was, gee, in your experience, and then his answer was, oh, well, it's been documented. I objected at the time because he was being allowed to testify from a document, not in evidence, and now he's acknowledging that that's in fact exactly what he's.
No, I don't think he's referring that it's been documented. Unless we get into the basis for particular documents, your answer needs to relate to your experience.
My experience. Okay.
Well, okay, but what I'm getting at, I just answered that question and got the answer, and I said the documentation is the materials to your left, correct? And he said yes.
Is your experience based upon those materials? I mean, is it your general experience outside of those materials that gives you that?
There's other documents and my experience of working on mine sites. I've observed
Can you speak up a
species.
little?
My experience, there are other documents
Well,
that document these
yeah,
species on reclaimed mined areas. In my general experience as a mine inspector and other being on mine sites, I've observed those species.
Okay, so that's your personal experience. Since this thing is up here and is with the witness and has been obliquely referred to anyway, I think he has a right to look at it and at least see what this thing is that we've got on the table.
And with all respect, Mr. Chairman, I don't know if we're going to finish today. I'd like the opportunity to look at this over the lunch hour and, if needed, to recall this witness after lunch.
Well, yeah.
I'd object to that. I mean, he needs to, we're not relying on this. I'm not offering it as an exhibit. We
Yeah.
haven't,
Well, I'll make my request, and we can
I'm not sure that it's been brought in that it really used for anything yet. And
Okay.
I think you have the right to look at it.
Okay, I understand.
But I don't know that we're going to take
Okay.
testimony on it.
What, you referred to some documents other than this material, correct?
Mm-hmm.
What are those documents?
There are documents in Ohio Wildlife magazine produced by the Ohio DNR, documents those species occurring on reclaimed mine sites, southeastern Ohio.
Okay.
Close to-
And that's outside the state of West Virginia, correct?
Yeah, it's bordering state. Also,
It's
Art-
not in Kanawha County, though, correct?
no,
Okay.
articles in Kentucky Afield magazine produced by the Kentucky DNR.
Okay,
with various-
another document relating materials outside the state of West Virginia, correct?
Mhm. There are various studies done within the state of West Virginia documenting.
Okay. Are there any
species.
documents relating to studies in the state of West Virginia other than the documents introduced into evidence by Mr. Wood in 177 through 181 of the first volume of exhibits?
That's a breeding bird atlas. These
Okay, is that a
here,
yes or a no?
are there other documents besides these that document species existence within the state of West Virginia?
Those species.
Yes, there are other
Okay, what
documents.
are they?
There's bird atlases, there's bird resources depicting ranges of species.
Okay, and do you
the
have any
breeding
of those
bird
with you?
atlas
Do you
is
have any of
not
those
the-
with you today?
No, the breeding bird atlas is not the only documentation of species range in existence.
Okay. Referring to your experience as a mine inspector, how many mines in Kanawha County have you examined that had these bird species?
How many mines have I?
In Kanawha County?
Yeah, I'm not sure I understand the question.
Okay. You talk about, you know what a mine in Kanawha County is?
objection.
I'm trying,
Yeah.
well,
It's
okay.
argumentative.
Be respectful of the witness. I mean, he's inspected
Well,
for
okay,
10
he
years.
says he doesn't understand it. I'm trying to spoon feed it here. Did you examine, as a mine examiner, did you examine mines in Kanawha County?
I have been on mines in Kanawha County, within the DEP, within my
Been on,
work
okay.
in DEP.
Okay, is the word been on, is that different from examine?
Are you what is a mine examiner? I don't
Well,
understand the term.
I understood that to be your primary, you mentioned that you were a mine examiner, correct? Is that correct?
That's incorrect. I don't know what a mine examiner is.
Do you know what a mine inspector is?
Yes, I do.
Okay, that was your title. Okay, have you ever inspected any mines in Kanawha County that had the species of birds that were referred to in the paragraph on forest in the letter that you found, that you discussed?
I did not inspect any mines. I have, through my current job, I'm no longer a mine inspector. I have been on mines in Kanawha County. I was on a mine in Kanawha County approximately 2 months ago where I observed northern harriers. I observed horned larks.
Which mine was that?
This was, actually, it was one of the Keystone mines. Well, we were on 2 of them. I observed horned larks on the mine. I observed northern harriers on the mine. I
Can you
observed,
speak up again?
yeah, I'm sorry. I observed horned larks, northern harriers. So what were some other species that we saw? Meadow larks. Those are the few that I remember from that 2 months ago.
Okay. Did you make any contemporaneous recordation of those observations?
No.
Are you aware of any documentation by anybody else inside the DEP of those species having been found in Kanawha County at mine sites?
It is not typical habit of personnel within the DEP to record observed flora or fauna on mine sites.
No further questions.
I don't have anything.
You don't have any? Mr. Wolf?
I'd just like to ask, none of the bird species we're talking about are endangered species, correct?
No.
No, sir.
Mr. Jones?
No question.
The board have any questions?
Yeah, I have a couple. As I understand it, what you're saying is that Fish and Wildlife or whoever puts these on the endangered species list will probably not do that until April of 2015, is that correct?
Are you referring to the northern long-eared bat?
Yeah.
Yes. When the species is proposed to be listed, they have to go through a series of requirements that they have to do, and it's 12 months from that. So it was originally proposed in October of 2013. Due to the tremendous amount of comments and requests that were made referring to the Fish and Wildlife Service over the long-eared bat, they have now pushed that date back longer so they can address all of these comments
Okay.
to April of 2015.
And I think you said something about, at that time, then you would be required to come up with protective measures for the,
That was the guidance. That's what the
The guide
guidance
said
ran.
that?
That's what we were informed of, and it's also in the
okay.
January guidance.
Now,
that-
what type of measures might you consider if in fact the northern long-haired bat is on the protective species list?
As it says in the guidance, we would, it would be similar to what is already done in relation to the Indiana bat. Many of the protection and enhancement measures that are used for the Indiana bat would be applicable to the northern long-eared bat. And there would be a protection and enhancement plan that
Okay, on
that
the
would spell
document
those out.
that you referred to earlier,
This-
on page 5 of that document, it says impact on the northern long-haired bat and the winter habitat. And if you go down 1, 2, 3, 4, it talks about blasting. And it says you will not have any blasting or drilling within a half mile of caves or mines where the northern long-haired bat is, has a habitat.
Well, this says blasting or drilling with may disturb hibernating bats. There are studies, there's a study conducted by the DEP in relation to blasting and hibernating bats. And we would have to apply, we would have to consult with the Fish and Wildlife Service and the DNR, and we would determine whether or not what would be applicable in this situation. The geology and things would make a difference.
What would you think would be applicable? I mean,
I'd have to study the area and the geology and
well, if we wait till April, that will be after the winter habitat, if there is such a habitat in the forest, wouldn't it? So
After April.
blasting it with this mine permit is probably going to be within a half mile of the Kanawha State Forest, is that correct?
possibly I'd have to
Well, there
measure.
was suggestion, and I'm not sure on the plan, that maybe they would be mining on the other side of the mountain first before they come onto the Kanawha State Forest side. If they do that, is that beyond a half mile, or do you know?
May I think you may have a misunderstanding.
Maybe I do.
The term hibernacula, hibernate during the winter, that means that they're in a cave or a portal or that when they hibernate, which is termed as a hibernacula, they go into caves or portals or something such as that during the winter. So there would have to be a specific cave or portal or that the bats were found. And in our original,
Which is where
we
they-
didn't find any.
Which is where
originally.
they normally hibernate, right? To be in a
Right.
vast.
Yeah.
Are there any caves or
Our original, so we did not
Mines.
find any.
there are mines in this area, but we don't know if there's any that have a sort of a cave structure. Do you know?
We haven't, and there's specific survey period for the caves and portals. They have to be surveyed within much
Okay.
as the summer sits in September to October. So if we become aware of any, find any, we would require them to be surveyed. That can't take place till September, and then we would take appropriate action, whatever that may be, to address them.
Okay. If you do find some, it might be a problem with the blasting regulations then, right?
We would just have to address it and
Okay.
specific.
If you go down two more items down, it says clearing the trees within 5 miles of caves or mines. If you find any caves or mines within 5 miles of the Kanawha State Forest, or within the Kanawha State Forest, that would be a problem as well, because the trees would already be removed, wouldn't they?
At the time the species isn't listed, we can't, I don't understand really what you're implying.
Well, the concern would be if the mine is already starting and they remove trees, and then after we find out that the northern long-eared bat is on the endangered species, then that 5 mile area will already been disturbed.
Possibly. It would be something that we would have to consult with the Fish and Wildlife Service and the DNR in relation to the bats. Right now, in our PEPs, the timber cutting is restricted to wintertime.
So have you discussed, or do you know if anybody within DEP has discussed with Keystone or Revelation about the possibility, if this gets added to the list, how the impact that might have on the mine?
Yeah, they would have to write a PEP, Protection and Enhancement Plan.
And shouldn't you probably consider going out and surveying whether there are any mines or caves
That was done.
beforehand?
That was done in the original permit.
It was done?
Yeah, that's part of the Indiana bat.
Okay. I think you said the Indiana bat wasn't there.
It wasn't there. But when you look for caves, Indiana bats use caves and portals the same as northern longhorns as well.
But are there caves and mines in the area? When you-
None were discovered.
None, you found none?
None were found by the
Okay.
consultants who did that work.
Thank you, that's all.
Any other questions from the board? Mr. Wanning, have anything to respond there?
I have nothing further.
How about Mr. Hoyer?
Nothing, sir.
Mr. Jones? Any other questions then?
I don't have any.
No further questions at this time.
Okay, you're-
I want to reserve the same thing. We're going through this at the moment, and I'd like to have, I just want to let the board be aware that depending on what we find in it, we may want to recall this witness.
You're excused.
At this point, I guess you want to talk about what you wanted to about lunch breaks?
Yeah, we can take it now, or if your next witness is going to run beyond that and you'd rather just do it now, we could just take time right now.
That's all right, yeah, he's definitely going to run. beyond.
Let's see here. Telling me. Okay, she's telling me that we have an exhibit that needs to be moved into. It needs to be
The interim
moved for
guidance
admission.
document?
Sorry, yes, and I would move that, the introduction of the guidance.
Okay.
No objection.
No objection.
If I might,
I don't know what it's
your
DEP
number
one.
DEP
Yeah.
one.
Right. It's the Northern Long-Haired Bat Interim Conference and Planning Guidance, right?
Yes, sir.
Okay.
Mr. Chairman, if I might, I just wanted the smaller volume 2 of exhibits I distributed earlier today. I just want to point out items 0, 1, 2, and 3 are documents which were requested by the board at the last hearing, and those were the prior CVs of Mr. Wood. And I point that out for the board's benefit.
All right. Okay, then we'll go off the record and maybe get back here at, to try not to make the same mistake about 1 o'clock. Is that all right for everybody?
Yes, sir.
Thank you. Thank you.
Last time I only gave us 15 minutes.